Somewhere in a Whitehall filing cabinet, there is a confidential security document. It names Prince Harry as the target of an al-Qaeda assassination call, 6 active terror plots, and roughly 250 known stalkers, 4 of them convicted, 4 of them currently unaccounted for. It was submitted to the committee responsible for his protection. They read it. Then they wrote back with their offer. A phone number, not armed officers, not a review. A contact number for a police liaison. And now Harry is days away from landing on British soil. That document is not classified rumor or tabloid reconstruction. ITV News obtained it. The security assessment commissioned by Harry's own firm, Criterion Security, and formally submitted to the Royal and VIP Executive Committee, RAVEC, is real, verified, and now public. The threats inside it are not historical curiosities. They are live. The al-Qaeda call, the 6 active plots, the 250 known individuals, 4 of them convicted, 4 of them currently unaccounted for. That is the verified picture of what the British state was handed, considered, and responded to with a phone number. Harry lands in the UK next week. What is not confirmed, what no one close to him will say on record, is whether Meghan, Archie, and Lilibet are traveling with him. That decision, still unmade or simply unannounced, is the fault line running beneath everything. Because the moment the family crosses that threshold, the question of who holds legal and moral responsibility for their safety stops being theoretical. It hasn't been answered. It should have been, long ago. To understand why it hasn't, you have to go back to the moment the system was first asked to protect him, and what it chose to do instead. The system that was supposed to protect Harry did not fail in a single dramatic moment. It failed in the slow, administrative way that institutions prefer, through process, through structure, through the careful language of procedure applied to a decision that was anything but procedural. When Harry stepped back from senior royal duties in 2020, the sovereign grant funding for his protection was withdrawn. That part, at least, was publicly acknowledged. What was not acknowledged, what has never been adequately explained, is that Harry remained 5th in line to the throne. The line of succession is not a courtesy title. It is a constitutional fact, and it carries with it a specific, documented threat profile. Removing someone from a payroll does not remove them from an al-Qaeda target list. Those are not the same ledger. RAVEC, the Royal and VIP Executive Committee, the body charged with making these assessments, reviewed his case and concluded that automatic protection was no longer warranted. The decision was framed as procedural, and the review process built into that decision, the annual Risk Management Board convened specifically to reassess cases like his, was never once used, not once in 6 years. A body designed to course correct, created precisely because threat environments shift, sat dormant while the threat environment shifted dramatically around it. That is not an oversight. That is a choice sustained across 6 years and multiple occasions on which it could have been reversed. The structural problem goes deeper than inaction. RAVEC has 9 members. 3 of them are Buckingham Palace staff, the body tasked with independently assessing the security needs of a man who had, by 2020, placed himself in direct conflict with the institution, sits 3/9 stacked with that institution's own employees. Nobody appears to have flagged this as a problem worthy of public scrutiny. Harry's legal team flagged it in court. The courts acknowledged the conflict and declined to override the decision anyway, which is its own kind of answer. Harry's lawyers have been building towards something for years now. The litigation against the Home Office, the judicial reviews, the formal requests for classified threat assessments. None of it is random. It is a paper trail, assembled with the specific goal of creating a documented record of what Harry asked for, when he asked for it, what he was told, and what happened next. The intelligence report on the 6 active plots, the al-Qaeda material, the 250 flagged individuals, some of that material has been part of legal proceedings. Some of it has not. The fact that it has now reached ITV, that it is sitting in a broadcast newsroom rather than a courtroom, suggests Harry's team made a deliberate decision about where it needed to land next. The public is the audience they could not reach through the courts. And the timing is not incidental. The report surfaces the week before Harry flies to London, the week before an unannounced decision about whether his wife and children cross with him, the week before the fault line either holds or fractures. But to understand why this specific moment carries the weight it does, you have to go back further still. Not to the policy decision, not to the committee vote, but to the specific sequence of events that first put the question of Harry's safety into formal dispute. The moment when the system was directly confronted with what it had done and chose the language it would use to defend it. That moment has a date, and it changes everything that follows. That date is the 14th of February 2023. Not a coincidence in the calendar, just the day the paperwork arrived. What arrived was not a vague threat assessment of the kind that intelligence services produce routinely. The boilerplate risk language that gets filed, acknowledged, and quietly deprioritized. This was specific. The FBI had been monitoring a closed Telegram channel with documented links to al-Qaeda operational networks, and what they found on it was Harry's name, not a category. Not a general incitement against the Crown or Western targets. A named call, his name, circulated to followers with active footprints in the United Kingdom and the United States. The intercept was passed to Harry's legal team. That transfer alone carries weight. The FBI does not share operational intelligence with private citizens out of courtesy. They share it when the threat is credible, when the sourcing is solid, and when they believe the named individual needs to know. The document was, by any formal definition, undeniable. Not rumor, not tabloid inference. A foreign terrorist network, naming a specific member of the British royal family with reach into the country he was being asked to enter without protection. His legal team took it directly to RAVEC, and RAVEC's response, when it came, did not engage with the intelligence at all. There was no revised threat assessment, no formal acknowledgement that the material changed the calculus. What Harry's team received, according to his legal filings, was a liaison phone number, a contact should he wish to discuss arrangements when he traveled, the bureaucratic equivalent of a shrug delivered in official stationery. This is the sequence that matters, not the abstract argument about whether a private individual should receive taxpayer-funded protection, not the philosophical question of what duties the Crown owes a non-working royal. A foreign intelligence agency handed the British Executive Protection Committee a document confirming that a named terrorist network was targeting Harry on British soil, and the committee's response was, "Call this number." The question that sits at the center of his legal case is not whether RAVEC made the wrong call in some technical procedural sense. It is whether RAVEC made a decision they knew was indefensible and made it anyway, because the political cost of reversing course, of admitting that the removal of his protection had created an exploitable gap, was higher than the legal cost of defending it. The courts so far have let RAVEC's reasoning stand. The judges have treated it as a matter of discretion, of resource allocation, of executive judgment. Harry's team has treated that framing as the problem. Discretion does not dissolve accountability. Judgment does not extinguish responsibility. And if the system made a decision in full possession of that intelligence, then the system owns what comes after it. That is the argument, and it has never been answered. Not in any courtroom, not in any ministerial statement, not in any communication from the palace. It has simply been deflected, repeatedly, with the same procedural language, the same references to process, the same assurances that the right people made the right calls through the right channels. But the right channels received that intercept, and they sent a phone number back, which means the question of who is responsible was never actually closed. It was just left open quietly and hoped no one would look too hard. Someone is about to look very hard indeed. That question, who is responsible, has just been answered. Not by a court, not by a leak, not by Harry's lawyers drafting another filing, by the committee itself, by the paper trail it created, the intelligence it logged, and the decision it made anyway. RAVEC is now on record. They received it. The FBI-sourced intercept, the specific threat matrix, the names attached to the risk. They had the intelligence in their possession before Harry's arrival window opened. And what they sent back was a phone number, a private security contact. The suggestion that a man who had already been the subject of a credible assassination plot should ring ahead and sort something out. That is no longer allegation. It is documented, which means the word unforeseeable has been permanently removed from any future defense. If something happens, in a car park, outside a venue, on a route from an airport, no minister can stand at a dispatch box and claim no one saw it coming. They saw it. They logged it. They chose. And then there is the structure of the committee itself. Buckingham Palace holds 3 seats on RAVEC, 3. The same institution that stripped Harry of his protection. The same household whose relationship with Harry is, to use the most diplomatic possible language, adversarial. Those 3 seats were present when every assessment of Harry's threat level was made. They were in the room when the FBI intelligence was received and the response was calibrated. That is not a procedural footnote. That is a documented conflict of interest sitting at the center of a security apparatus that answers to no independent oversight. Harry's legal team now has something they did not have before, a clean line between the decision makers and the interested parties. Courts tend to find that significant, but strip away the legal architecture for a moment. Strip away the filings and the committees and the ministerial language. What you are left with is this. King Charles has not seen Archie or Lilibet since 2022, his own grandchildren, and somewhere in a classified file that RAVEC received and chose not to act on, there is a credible threat assessment that names those children within a risk profile. The grandfather on the throne and the grandfather who receives intelligence briefings are the same man. He has not called for an emergency review. He has not made a public statement. He has not, by any account that has surfaced, picked up the phone to his son and said, "I know what the committee received. I want to know they are safe." The silence from that direction is not neutral. It has weight. Now comes the part that cannot be walked back. Harry is traveling. The visit is imminent. And the choice that sits in front of Meghan, in front of the lawyers, in front of everyone who has been watching this case build for 3 years, is the one that was always going to arrive eventually. Do the children come? Does Meghan? If they stay in California, they stay safe. But the fracture becomes a photograph. The image of a man arriving at his grandfather's country alone, his wife and children kept back across an ocean because the protection his family should guarantee was denied. That image does not require a caption. Every outlet that covers it will understand exactly what it means. The palace cannot manage that narrative. There is no briefing that neutralizes it. There is no courtier who can make "we couldn't guarantee the children's safety" read as anything other than institutional failure at the most fundamental level. And if they travel and something happens, anything, a credible incident, an approach, a breach, the responsibility has already been assigned, not retrospectively, not through interpretation. It was assigned the moment RAVEC logged that intelligence and sent a phone number. It was assigned when the palace's own representatives sat in those committee seats and the outcome was still nothing actionable. The paper trail does not wait for a verdict. It already exists. That is where this ends. Not with resolution. Not with Harry vindicated in a courtroom or Charles making a statement or a minister resigning. It ends with a live wire left in the open and 2 impossible outcomes on either side of it. The people who created that situation know exactly what they created. They are hoping, as they have always hoped, that the weight of it eventually breaks Harry before it breaks them. What they did not account for is that he kept the receipts. Every intercept, every logged decision, every procedurally correct non-response, it is all there. And it is not going anywhere. If this story has disturbed you or angered you or made you want to understand how institutions this powerful continue to operate without consequence, then stay with this channel. We will keep watching. Hit subscribe and make sure you don't miss what comes next, because on this particular story, something always does.